Somebody told me to hit the button. All right.
Okay. Good afternoon, everybody. Welcome. Sorry about the room.
Yes, while you start.
A little bit?
Yeah, Thomas says it's warm. Are you going to leave, Thomas? Okay. Thanks, Thomas. Thomas Richards, everyone, board member. Welcome. We're all hooked up. This session is implementing the Oregon Student Information Protection Act, which goes into effect July 1st. And so we've got our friends from the Department of Education and the Department of Justice here. And so I'm going to let them introduce themselves and just turn it over to them. Welcome and thank you.
All right, so for some of you, this is going to be a repeat. Any of you IT managers sitting in the room, you may want to escape because you're going to hear a lot of the stuff that you've heard from us already, right? Or if you've been to an OSIPA event in the last year. So I'm Susie Stringfield. I'm currently the interim CIO for the Oregon Department of Education, and yes, formerly of Candy. And yes, we do also recognize we're between you and the food upstairs, so we'll try to keep this brief and just give you the basic nuts and bolts of what's coming, why it's coming, and some best practices around implementation of OSIPA or OSIPA, depending on where you might be from. To your, what is that? Left, my right, this is...
I'm Cheryl Heemstra. I'm an attorney with the Oregon Department of Justice, which means the Attorney General is my boss. That's how that all works out. And the Attorney General was sort of the force behind getting this all going, and then we worked with a lot of partners to get it passed through the legislature. So I'm here to kind of explain the story behind the law and sort of how it works and how we're going to be enforcing it.
And I'm Amy McLaughlin. I'm the Director of Information Security and a few other things at the Oregon Department of Education.
Yep. There we go. And I'm standing because it's too hot to sit down. So.
And I'm sitting because I am 7 months pregnant. What is OSIPA? Basically how this all started was we took a look at what's been going on in the world. If you're a techie, you've seen Moore's computing law before. As time goes on, the cheaper information gets to produce, the more information we're going to have. I read an article recently that by the year 2020, there's going to be 40 zettabytes of data out there. And if you're not a techie like me, that translates to 57 times all the grain of sand on all the beaches on all the world. So there's going to be a lot of data out there. There already is, and it's just exploding. So how does this intersect with the law? One of the idioms I keep running into is technology is fast, the law is slow, so very slow. And so we're going to be talking about the current laws that are in place right now and kind of the hole we found in education and why we needed OSIPA to fill that hole. So I'll turn it over.
Okay. So probably a lot of you are familiar with some or all of current privacy laws. Obviously, FERPA, the Family Educational Rights and Privacy Act, is one that most all of you live with all the time, which just governs who can access the student's data and for what purposes. COPA, the Children's Online Privacy Protection Act, more about how you protect students accessing online resources. HIPAA, protection of our health records and health data. And the USDA, and some people look at me funny when I say the USDA, but the National School Lunch Program data, it's all heavily protected under USDA rules and regulations about how you can use that data, or pretty much about how you can't use that data. And closer to home, the Oregon Identity Theft Protection Act, which talks about what happens in Oregon if combinations of protected data get exposed, and responsibilities of both businesses and nonprofits, government organizations, in responding to and dealing with those kind of breaches. In fact, probably many of you, and how many people in this room have ever gotten one of those like letters in the mail that says your credit card has been compromised, or your health, our server got hacked and your records may have been compromised. Somebody filed for your taxes under your name. Right? So those are all those notification pieces. But even with that said, the OSIPA came into place because with all those current privacy laws in place, it was not enough to protect students in our school systems and their data from being used. So existing privacy laws today do not cover, just make sure that's still mine, okay, keep going, do not cover things like data that's collected by vendor systems from release or transfer of that information by third parties. So when a student's working and it's collecting data, there was no protection for what happened to that data later. Student privacy when they're using it to access online education systems and resources, and ownership of who owns a student's data in those vendor systems, or any rules or requirements around how that data gets aggregated and used later for non-educational purposes. And that data that's collected and used and sort of exposed had potential to be a pretty broad set of data, which kind of broke down into three basic categories: contact information, who is the student, first name, last name, phone numbers, email addresses, other ways to find the student. Their school performance information, so how they did on tests, how they did in terms of grades, evaluations, any disciplinary records or special ed records. And then the catch-all of all other records, which in terms of what a student has in systems or maybe entering, could be health information, their social security number, their thumbprint for biometrics. You know, maybe you scan your thumb to get into the system at the beginning of the day, down to text messages, search activity, photographs, all kinds of data, because data is just about everything that goes in the machine. Some very, very sensitive. So, the challenges that came up, or the questions that came up, was who owns the data and what are they doing with it? So data, you know, if the data isn't owned by the students and it's being used to develop marketing profiles that are attached, like if you're an 8-year-old student and you start entering data into a system and they start tracking you from the age of 8, how many of you in this room did things when you were a kid that you would be mortified to have stuck in a database somewhere today? Yeah, oh, somebody's like brave enough to confess. I mean, I'm sure I did too, probably things I've long forgotten. But that kind of information, starting to build a profile of a person where, you know, people, especially young people, get the option to grow and change as individuals. They shouldn't be tethered to their past of things they did online when they were 8, so, or younger, or older. And then also, you know, when students are working on school and educational processes, they shouldn't be being used as a target audience for marketing. So getting tailored advertising to students based on their profile that's stored in that vendor system. And also the question of, can vendors sell that data to continue to do more profile development and targeted advertising? So
yeah, we took a look at all those questions. And the Attorney General, one of her big priorities has been privacy, especially in the consumer context. She got together a bunch of folks at a privacy symposium, some academics from Berkeley, some other attorneys general, some legislators from our Oregon House and Senate, some people from the tech field, some lawyers who represent big data mining companies, a whole bunch of people together. And what we talked about was a lot of the different things, but one of the themes that kept coming up was this whole in education. Some of you may be familiar with Representative Lou Frederick, who had been sort of carrying this flag for many, many years, and had a lot of ideas about what to do. So we took a step back after that symposium, and we said, okay, what can we do here? We started looking around at other laws across the country, because this has been bubbling up everywhere. There was a bankruptcy case over on the East Coast where ed tech company had been going into bankruptcy, and their data was considered one of their best assets. And that got everybody pretty worked up. So New York was looking at this, California had been looking at it, and California was actually the first to pass a law in this area. It was called SOPA, the Student Online Privacy Information Protection Act. Passed unanimously down in California, so we said, hey, let's just copy that. That looks like a pretty good law. It does a lot of good protections. Should be a breeze. In enter Oregon. It was not a breeze. What the California law did that kind of, I think, took tech companies a little bit by surprise was most privacy laws have a loophole in them, and it says as long as you consent to whatever use we want to use it for, as long as you consent, we can use it for whatever we want, right? We've all been through these click-throughs. I never read them. You probably never read them. I think there was a study by the ACLU. If we actually did read them, we need a legal education and like 300 extra hours a year to actually like read the text of them, right? So the California law did not have that consent piece in there. They got it through without that. And that became the biggest bone of contention for our law. There's a similar session going on right now about the Washington law. A lot of other states passed student privacy legislation last year. Washington law, all those other ones did have a consent piece in there. So, well, companies, as long as you get somebody to sign off on a click through, we can use the student information for whatever we want. Our Attorney General said no. We are going to try to pass this thing without that loophole, and it took a lot of collaboration, a lot of blood, sweat, and tears, but we did pass it without that loophole. We worked with the Oregon School Board Association, PTA, and Department of Education was there at every single hearing, explaining the technical and on the ground aspect of what we were seeing. So it was quite a journey through the legislature, but we did end up passing Senate Bill 187. Which, if you're a law nerd, is now codified as ORS 336.184. So there you go. So what the law does, it only applies to K-12 students, and there's a great little one-pager we put together that's on ODE's website that you can look up. But here's basically what the law does. So first it goes through what tech companies can't do. First of all, I want to clarify, it only applies to ed tech companies. It's defined in the statute as operator, and this means a company that has knowingly made software or any application for schools, and they know it's being used in a school and it's being used for school purposes. So, Google on a student's phone, no, that's not what we're talking about here. We're talking about specifically things for education while being used in the educational context. So what they can't do, they can't sell the student information individually. That was pretty much a no-brainer. We didn't really get a whole lot of pushback on that one. They may not target advertising to students. A lot of work went into what does target advertising mean. If you're curious, you can look up the law. But basically, you're not allowed to take student information that's been collected during the educational purpose and then use that information to target ads. There's many exceptions in the law for around that definition. Obviously we can't get rid of all advertising and all of Google and all every search. So if it's somehow specific to a certain search or something like that, occasionally advertising, as long as it's not targeted to the student, is okay. We can't get rid of all advertising. I understand. You cannot use specific information collected about a student to serve them ads. Same idea. It may not create a profile on a student unless it's for school purposes. In the language of the statute, it is amass a profile. What was the real concern was that, again, with that bankruptcy case, they had all this information on each student, and we're just selling it, and we're going to sell off the profiles. So another concern with those profiles is not only does it target the student, but you can get some demographic information about the family. And the Attorney General will do a lot of work with financial fraud and that sort of thing. And with so much data on the student, you can figure out, maybe who's lower income, more vulnerable to a bad scam, something like that. And the data mining that goes on, I'm sure most of you in this room know, it's just incredible what they can tease out from just a few points of data connected up with the data mining they've already been doing and start targeting not only students but their families as well. So what the ed tech companies must do, they must have reasonable security measures in place. This is sort of already the law under the data breach law you heard about earlier, but this just makes it explicitly clear that this is students' information. This is sensitive. We want to have it protected. And you also must delete the student information when the school asks them to delete it. We had some shades of differences with a couple folks on that one. Some folks came to the legislature saying, no, I want them to delete it, as soon as they graduate. Well, we heard from schools saying we need sometimes that information for transcript purposes, or, there's some shades here where we need to keep it for longer. So we put the sort of control in the school's hands there. What ed tech companies can do, they may disclose student information to make technology work for school purposes. We got a lot of pushback from the tech companies saying, well, you're just going to quash innovation, it's just going to break down our whole system, we're not going to have to function anymore. And we said, okay, well, we'll give you an exception. If it's for a school purpose, if it's for educational purposes, by all means, take that student information, make it a great learning experience for the student. They may use anonymous student information for research purposes. We didn't want to shut down or mess with any of the the Common Core and the assessment.
Smarter balance, looking at formative and summative assessments.
Yes, all of that. We didn't want to mess with that. They use student information when responding to a student's request for information. Tech companies came back to us with our original version of the law and said, well, what if a student is asking a question, we need to maybe have some profile information to respond to them. We said, okay, that sounds educational, that's fine. And there's some other exceptions in the law that we need to get in there for functionality purposes is mostly what we were thinking of there. So a quote from our great Attorney General, these educational tools are valuable, but Oregon must draw clear lines when it comes to our children's data. Our students should not become a captive audience for targeted corporate marketing. And kind of like we were saying before, one of Ellen's big priorities here was grades follow you forever, but now it's all this other information too that's going to be following these kids forever. So we really wanted to put a common sense fence around this and say, all right, learning is for learning. Let's keep that information there as much as we can. So that's the basic outline of the law. We'll get to the enforcement and how that piece works in a few minutes.
So, thinking about this law and the implementation timeline. So again, Senate Bill 187 was passed. It's been codified. It goes into effect July 1 of this 2016 of this year. What that means, though, is that we all need to start thinking about what does implementation really look like. So, working with the Attorney General's office, actually, we were able to get some sample language for contracts. So we've looked at terms of service and we have some sample contract language that we have posted. And it's one of those things, too, where you need to maybe take a look at your board policies, and especially around the areas of PII and how you handle student data, and also potentially when you look at your instructional materials and some of your curriculum adoption. Now that we have all different types of materials that are out there, we really do need to take a look at it and make sure everybody's aware with the right lens of what those contracts should look like, and at least have the right language in there about student data privacy as far as when you're talking about OERs. So online educational resources. Yes, there you go, that's great. So then back to updated policies and procedures. This is where we were thinking, when we started looking at some of the stuff within board policies. Again, Oregon is super fun in the fact that we have local control. Looking from our lens up here, where we're coming from a state department of some sort, we still honor and respect the fact that in Oregon, local education agencies we want to make sure that it's in your hands how you're going to implement and actually ultimately this hits the ground running, right? So there's a lot of different things where you can tweak it a little bit. We give you, here's broad brushstrokes, here's how we'd like you to implement. But when it actually comes into your hands, we'll look to OSBA to help us with some guidance around some of these pieces because they're another partner in this. But really how it is implemented in your district, we're not going to give you a specific recipe, it must look like this, right? There's different needs, different ways, people are at different places with their innovation and how they're actually using different online educational resources in their curriculum. So again, trying to be broad enough that here's some guidelines, but not really prescriptive. Let's see. So again, we were thinking about, as we've been discussing this with lots of folks, and it's not just the Attorney General's office and ODE, we've been actually reaching out to many of our peers in the districts to have these conversations. So we were talking about approval process for the use of software, and the software selection processes. If you have those in your district, you may want to add a line about the student data privacy, and you might want to think about how do you then, if you move forward, the other way.
You're going backwards to that.
Go forward. Sorry. We'll come back to that.
Okay.
Right here. So you might want to think about maintaining a list of vendors. So there are a number of ways that you can do this. I think about Susan in Tiger-Tualatin, right, where she's got a running list of those folks that have actually have the right terms of service in their contracts. When they look at some of the apps that they're buying, again, she's keeping a list of those that they've kind of vetted and that they know that they've got some of that student data privacy addressed in some of the pieces in the terms of service. So she has a running list that they keep. I'm not saying that everybody needs to rush out and do that, and I also believe that we should be collaborating using some of the, if she's already done some of that work, how do we share that, right? So there are pieces here where we've been talking at IT managers about how do we kind of start implementing this in a smart way and not overwhelming folks and saying you must have it approved by the technology office before you actually get to download an app, right? And there's some things about, like Cheryl was saying with the click-through, that even with a click-through, the law still protects the student's privacy, right? That was one of the points of the law. So again, looking at how could we do this that doesn't slow down innovation and use in your district, but still keeps people mindful that the contract language needs to be tight enough to protect. We'll go back up one. So we brought in with us the sample language. This is also posted up on ODE's website in multiple places, and then we'll get to that link. It's at the end. But we do actually have a information security and privacy page on our website. But again, just ensuring that it uses the language with contractors, and it talks about how they may use it, and also as far as the acceptable use, and then again pieces about when they need to actually destroy it, and that's again at the school level. Let's see it in the.
So, if I could jump in a minute.
Yes, please.
The nice thing about this law is it doesn't really say schools, you must do this.
Right.
What it says is contractors, ed tech companies, you must do or not do this. So the burden is on the ed tech company to comply with the law. What this sample contract language does, it just says, hey company, you're on notice, we've got this weird Oregon law, please, you're in charge of complying with it. It's basically all the contract language says. So, the Department of Justice probably isn't going to be coming after your school district for being out of compliance with OSIPA. That's not how the law works at all. We'd be coming after the ed tech company saying, hey, you had this in your click-through that you were going to sell the student information. That's clearly not allowed under our law. So we can come in and we'll go after the ed tech company.
So even if it's not in the contract, they're still on the hook.
Right. Yep. Right. Absolutely. I think the key piece when you think about best practices and how are we going to implement this, is the conversations with your technology folks and whoever's doing your purchasing. And then again, notification with staff. There's some pieces here that teachers need to be aware that this is here and that it applies and what is it. So somewhere, how do you fit that into either a staff meeting or some sort of in-service conversation about student data privacy? And then you've had the conversation and there's some general awareness, because there's another piece in this when we get to, actually go back to that one. Oh, well, sure, you can go to part of it. Sorry, I want to hit the privacy pledge. This is fine. So again, just what do they need to know and what to look for, and really talking about, you're looking for those targeted ads. I mean, if there's something that's popping up because you know that they're aggregating and it's not education related, that's a problem, right? And those are those things that we're looking for when we start talking about enforcement in just a minute. However, if you go back up, sorry, our slides are, our conversation is going a different way. So student privacy pledge. I really think this is an important thing to talk about, and I'm actually going to have Cheryl speak to it because she has a better job than I do as far as the privacy pledge.
So this started maybe 3 years ago now, the privacy pledge. I think Microsoft was maybe one of the first, and we've gotten a lot of different folks to sign on. I think Apple finally signed on earlier this year. And what it was, and we've seen this with all different laws all across the country, is industry saying, okay, there's this heat wave coming of we want to have privacy for our students. Let's try to get ahead of it and say, look at legislatures across the country, we have a pledge. We pledge to protect student privacy. And there's actually some really, really good things in the privacy pledge. There's some things that aren't in our law that I wish were. So if you see student privacy pledge seal of approval on something, it's a good indicator. However, it does have that loophole in it that I was talking about earlier, that, well, as long as a student or a district consents to whatever use we feel like using it for, we're going to use it for that. So there's that loophole in there, so just be aware. It's not the same thing as our law, but it is a good indicator of a company that's probably trying to protect privacy as best they can. So.
Okay. All right, so we hit that, yeah. So enforcement, that's actually you too.
So yeah, as I was mentioning before, the enforcement here is through the Attorney General's office. It's actually through our consumer protection law, which gives us a lot of cool tools to use. We can actually basically send them a subpoena before we file a lawsuit against them, so we can sort of kind of get some pre-investigative information about what's been going on, as long as we have maybe an idea that maybe there's been a violation here. And when we send those letters out, boy, do companies get excited. So if you feel or see or have some indication that maybe there's been a violation here, what we can do is send out one of those letters. It's called a civil investigative demand. And we can say, okay, let us peek under the hood. What have you been doing with student information here? And you may not have all the pieces to put together. You might just see, hang on, how did this company all of a sudden, now they're getting an advertisement to my student in my classroom, or even outside of the classroom. I know that piece of information came from my classroom, and all of a sudden it's over here. If you don't need to know the connection, you can send a letter in and say, okay, company, we suspect a violation here. What's the connection? And they get excited because we can ask for penalties up to $25,000 per violation. So you add that across a classroom, school, a district, that starts adding up to pretty penny pretty quick. So that's how we're able to really get the attention of these companies. This is just my suspicion at this moment. I'm guessing the bigger companies will probably be in compliance, but it might be an app your teacher downloaded somewhere, or it might be sort of a new and rising up company that's never heard of Oregon or Oregon law. That's probably where we're going to find violations, but who knows? And this is going to be complaint driven. So, unfortunately, we do not have the resources to have a cop on this very specific beat. The cops are going to be you guys. And if you find something, please do let us know. We have a consumer hotline. We have a website where you can just email in the information. And we have our hotline folks set up to respond and get that information basically to me and two other attorneys in my office who have taken a look at it. Or you can talk to Susie at ODE and she'll get the information to us as well. We realize it's going to be maybe a little bit difficult to, like I said, connect that information, escaping the classroom and getting out, but you're going to be the ones to see it, so we would love to hear from you.
So,
If it's an outside company, outside the state of Oregon, you can still go after them?
Yes, as long as there's been an Oregon student involved, or Oregon information, or as long as there's some Oregon hook.
So I forget the exact wording, I never actually read this thing, but, so, who apply? You talked about companies that provide educational software. I mean, example, Autodesk provides software for every CTE program in the nation at high school level. Do they fall under this?
Are they directed to schools?
Well, they're depends on which end. I don't know what that means. Every architecture firm probably in the U.S. has their software. Their architecture, engineering, computer graphics software.
Okay.
But we use it in CTE programs for training kids to do jobs. So,
Sure.
is it directed toward education?
I would say yes, because they know it's being used in a school and it's not happening, right? So,
well, they probably have educational licensing that's differently priced, maybe? I would think that might be an indicator too. I don't know. Cheryl?
What about mobile apps? Mental apps?
yes, if they're made for education, then
And that's where we think you'll see the majority of the things that might pop up.
Would they be purchased? I mean, if there's a free app that you're getting from.
So we have some resources available through ODE that I just wanted to make you aware of. There's this website, and the easiest way to get to this, by the way, is to go to Google and type Oregon Department of Education and Privacy or Information Security and Privacy. It'll be like one of the first things that pops up. And then also there's the U.S. Department of Education Privacy Technical Assistance Center. I'm actually going to show you this site. So this is the ODE site. We keep an abundance, and sorry, it's so tiny on the screen. Let's see if I can make it bigger. We keep an abundance of links to information, including all the information about OSIPA, over here on the bottom right that we just added. Links to information about all the state laws, federal laws that impact privacy, and a bunch of background resource information on privacy, identity theft, and FERPA, and some planning things to think about too, as when you're looking at security planning, acceptable use policies, those kind of sample policies out there as well. So that's just out there all the time. Additionally, if you find really awesome, cool resources that you think we should add, feel free to email them to me, and I'd be happy to get those added. I'd like to kind of grow that resource over time so it's much more useful and dynamic. So.
Okay, so the one question that we've had multiple times, and they look at our Oregon education, the Google for Education contract. So yes, that one in particular, we have to go back and update soon. So when we go to update it, we will be adding this new contract language. So at the moment, they've signed the privacy pledge begrudgingly, I think.
Yes.
But we will be adding that to the terms of service. So
And there was some preliminary information in the original contract that limited what Google Apps for Education could do with Oregon data. So it was kind of funny that they even objected to the law because they'd already agreed to most of those provisions in the original contract. So it'll get updated, but yeah, right now most of those provisions are already covered.
any other questions?
So if we're using apps that aren't, specifically for education, then how is the student data being protected? Because those vendors don't have to comply, because we want to use real world apps, right?
Mm-hmm. So if and going back to that, if it's intended for K-12, that's what falls under that. Or if it's being used under a contract, so again, going through OETC and looking at some of those things where you're getting an education discount or an education price, again, I would assume that falls under OSIPA, but then when you talk about some of those that are not, and are not directed at K-12 purposes, then they don't.
The law's not gonna cover that. So they're protected as much as you and I are protected when we go on.
And so then doesn't that then fall on the district to, protect that student data?
That's gonna be up to the policy of the districts, yeah.
Okay, but the state doesn't have anything to say about that.
There's no law currently unless it's immensely deceptive or something like that we can really go after, that kind of behavior. That was more than we could bite off in the last session, so, yeah.
Right.
So if I'm buying software and they know it's Springfield Public School District, does that put them in the realm of knowing that it's used in schools and they have to abide by it?
It would depend on who you're contracting with. I would want to take a look at the contract and what you're going to be using it for and how much they target schools and if they don't. The law's got a definition, so we got to kind of compare the facts with what would be law for a specific contract.
I think you may have already covered this, but just to be clear, if there's, say, an educational software company in Arizona, and they have free educational apps that gather student data,
It's targeted at K-12.
and a teacher in an Oregon school district downloads their free app, doesn't notify the company in any way, but just downloads the app, starts using it, then that company is liable for protecting the student data?
Yes.
It's targeted at K-12.
So because they made it available for Oregon people to download.
To anybody under a K-12 premise,
Right.
for use for education purposes. and really not even K-12, but I mean, if it's for educational purposes, it falls. K-12.
K-12 under OSIPA, yeah.
Yeah, so the other thing that we've also seen, I wanted to make sure we say before we go, is that we are seeing a rise in kind of some of the pushback from the industry. So we're not sure what that'll result in the 2017 session, legislative session. So there could be more to come on this. And as some of these privacy laws evolve, we may be coming back to the table. And again, we're all kind of learning this landscape together. So contact us if you need help or if you're trying to, problem solve something. But we'll be there to help. Okay. Well, with that, it's 4:33.
We walked.
It's hot in here.
Thank you very much for sharing this with us.
Hey, oh, I turned